It feels like our personal info is just everywhere online these days. And for the longest time, there wasn't much in the way of clear rules about it.
Right. It was a bit like the Wild West.
Exactly. But that's really changing now, isn't it? We're seeing this, wave of data privacy laws popping up state by state.
Yeah, all trying to put some guardrails on how our data gets collected and used.
It can feel like a real maze, though, whether you're just trying to figure out your own rights or, if you're running a business trying to keep up.
Absolutely. And these aren't just suggestions anymore. These state laws, they have real impact. They change how companies operate and, critically, what rights you have as a consumer.
So that's what we want to do today, right? Kind of navigate this growing landscape with you. We've looked at a whole overview of these state laws.
To really pull out the essentials, what's happening, why it matters to you.
Exactly. We want to break down what you can actually expect now, what you can demand from companies, and flip side, what businesses need to be doing.
We'll touch on enforcement too, how these laws are actually being put into practice and what happens if companies don't comply.
Yeah, the goal is really just to give you the clarity you need to feel a bit more informed, maybe a bit more in control in this digital world.
And we couldn't do this kind of deep dive without support. So a huge thank you to our sponsor, globalcompliancemap.com. Their help is crucial for bringing these complex topics to you.
Okay, let's dive in. Where better to start than the state that really got the ball rolling? California.
Right. California. The CCPA, California Consumer Privacy Act, that went live back on January 1st, 2020.
And then they beefed it up pretty significantly, didn't they, with the CPRA?
Yeah, the California Privacy Rights Act, those changes kicked in January 1, 2023, so they've been at this for a bit.
So who exactly do these California laws apply to? Is it every business?
Not quite every single one, but the reach is pretty broad. It's aimed at for-profit businesses that collect personal info from California residents, and they need to hit one of three marks.
Okay, what are those?
Either their annual revenue is $25 million or more, or they buy, sell, or share the personal info of 100,000 or more consumers or households each year.
Sharing being key there, I imagine.
Definitely. Or the third one, if they make 50% or more of their revenue from selling or sharing personal data.
Gotcha. And didn't something change recently about who's covered, like employees?
Yes, exactly. As of 2023, the rules also cover data about employees and even data in a B2B business-to-business context. Yeah. Those earlier exemptions expired.
Okay, so it covers a lot of ground. Now, for folks in California, what new powers does this give them over their data?
Californians got a really solid set of rights. There's the right to know. You can ask a company, hey, what data do you have on me? How are you using it? Who are you sharing it with?
Okay, transparency. What else?
The right to delete. You can ask them to get rid of your personal info. There are some exceptions, reasons they might need to keep it, but the default is you can ask for deletion.
And the CPRA added something new there, too.
Wow. Yes, the right to correct. If you find mistakes in the data a company holds about you, you can demand they fix it.
That seems pretty fundamental.
It is. Then there's data portability, getting your data in a format you can easily take somewhere else.
Okay, makes sense. Keep going. This is good stuff.
All right, and the big one. The right to opt out of sale or sharing. And sharing is explicitly defined to include giving data for that cross-context behavioral advertising.
The ads that follow you around the internet.
Exactly those. You can say no thanks to that using your data. And for kids, it's even stricter. For anyone under 16, companies can't sell or share their data unless the minor or their parent, if they're under 13, actively opts in.
So it flips from opt-out to opt-in for minors.
Precisely. And CPRA also brought in the right to limit the use of sensitive personal information.
Sensitive PI, what falls under that?
Think things like your precise geolocation, your health information, racial or ethnic origin, biometric data. You can tell businesses, look, only use the sensitive stuff for the absolute necessary purpose you collected it for, nothing else.
That's a powerful one. Anything else?
Just one more core right. Non-discrimination. Businesses can't penalize you for using any of these privacy rights. They can't charge you more or give you worse service just because you asked to delete your data, for example.
Wow, okay. California really did go all out on the rights. So who's making sure companies actually, follow these rules?
It's a two-pronged approach in California. You've got the California Attorney General, and you also have the California Privacy Protection Agency, the CPPA.
A dedicated privacy agency.
Yep, that was a big part of the CPRA. And the CPPA got its full enforcement powers on July 1st, 2023.
And what happens if companies mess up? Are there penalties?
Oh, yeah. Penalties can go up to $2,500 per violation. But if it's found to be intentional, or if it involves kids' data, that jumps to $7,500 per violation.
Per violation. That could add up fast.
It really could. And here's a key change with CPRA. That general 30-day window businesses used to have to fix things, the right to cure, that's gone for most violations now.
So no automatic second chance.
Not for most things. The AG or CPPA can just take action. There is still a limited private right of action, meaning individuals can sue, but only for certain types of data breaches where a company failed on security. And even then, you have to give the company 30 days notice to fix the security flaw first.
Okay, so direct lawsuits are only for specific security breaches. Otherwise, it's the state agency's step again.
That's the gist of it. It puts more pressure on businesses to get compliance right from the start.
Makes sense. Now, when people want to opt out, especially of that sale or sharing, is there an easy way to do it in California?
Yes, California was a pioneer here. They require businesses to recognize universal opt-out signals sent from browsers or devices. Things like the Global Privacy Control or GPC.
GPC, right. I've heard of that.
The CPRA solidified this. Businesses must treat a GPC signal as a valid request to opt out of both sale and sharing. It's meant to be frictionless for the user.
So you set it once in your browser and it should just work.
That's the idea. And the California AG has been really supportive, even mentioning GPC in their enforcement guidelines.
That's definitely user-friendly. What about really sensitive stuff like health data? How does California handle that?
Well, data that's already covered by the federal HIPAA law is generally exempt from CCPA. But CCPA does classify health information outside of HIPAA as sensitive personal information.
So you get that right to limit its use.
Exactly. Plus, California has its own separate state law protecting medical info, the CMIA, which adds another layer. And it's worth noting that medical and biometric data are specifically listed in the data breach categories that can trigger that limited private right of action we talked about.
So strong protections there, too. Okay, it feels like California's framework is pretty well established now. What's been happening more recently? Any updates or controversies?
Well, the CPPA, that new agency, has been busy developing detailed regulations. There was a bit of a legal hiccup, though a court ruling delayed the enforcement of the new CPRA regulations until March 2024.
Okay. But the law itself was still in effect.
Oh, yes. The statutory requirements were still in force. And the AG hasn't been idle. Remember the Sephora settlement back in 2022? That was about them not honoring opt-out signals properly under the original CCPA.
Right, I remember that.
So enforcement is happening. And now that the CPPA's regulations are enforceable, we expect to see more activity from them too. There's still some industry discussion and pushback on certain details, but the core framework is solid. California definitely set a high bar.
Okay, a really thorough look at California. Let's shift gears. What about Colorado? They passed the Colorado Privacy Act, the CPA. When did that become effective?
Colorado CPA kicked in on July 1st, 2023, and they had a follow-up deadline too. The requirement for businesses to honor universal opt-out mechanisms started July 1st, 2024.
Okay, so a phased approach there too. Who falls under the Colorado law?
It applies to controllers, the folks making decisions about data processing if they do business in Colorado or target Colorado residents, and they need to hit one of two thresholds.
Similar to California's triggers.
Similar idea, different numbers. Either they process personal data of 100,000 plus Colorado consumers annually, or they process data for 25,000 plus consumers and get revenue or some discount from selling that data.
And consumers here means?
Colorado residents acting personally, not in an employment or B2B context. So employee data and business contact data are generally excluded, unlike California now.
Gotcha. And like other states, there are exemptions, right? Nonprofits.
Yep. Similar exemptions for federally regulated data like HIPAA, GLBA, etc. And Colorado, following Virginia's lead, specifically exempts nonprofit organizations.
Okay. And what rights do Colorado consumers get under the CPA? How does it compare?
It's quite similar to California and Virginia, actually. You get 5 main rights: access, correction, dilution, data portability, and the right to opt out.
What does the opt-out cover in Colorado?
It covers the sale of personal data, processing for targeted advertising, and also certain kinds of profiling, specifically profiling that produces legal or similarly significant effects on people.
That profiling opt-out is interesting. Does that cover automated decisions?
Yes. Colorado explicitly gives you the right to opt out of profiling if it's used for decisions that could significantly impact you, like loan applications or job opportunities, if those decisions are solely automated. Virginia and Montana have similar provisions.
That seems really important with AI becoming more common. What if a company denies your request in Colorado?
They have to have an appeal process. And if your appeal is denied, the company must tell you how to contact the Colorado Attorney General to lodge a complaint.
So, a clear path to the regulator. Who enforces the CPA then? Just the AG.
Primarily the Attorney General, but district attorneys can also enforce it, all under the state's Consumer Protection Act. And importantly, like many others, there's no private right of action. Individuals can't sue directly for CPA violations.
And penalties. Cure periods.
Penalties fall under the Consumer Protection Act, potentially up to $20,000 per violation, but the CPA seems to cap it practically at $2,000 per consumer, with a $500,000 max per related series of violations. Now, the cure period, they had a mandatory 60-day right to cure.
Past tense.
Right. That 60-day cure period sunsets, it expires on January 1st, 2025. After that, the AG doesn't have to give notice and wait. They can take action immediately.
Ah, another one where the cure period is fading out. Interesting. What about those universal opt-out signals? Did Colorado follow California?
They did, and quite proactively. Colorado was the first state after California to mandate honoring universal opt-out mechanisms. That requirement started July 1st, 2024.
So businesses have to respect signals like GPT now.
Yes. Controllers have to honor user-selected signals for opting out of targeted ads and data sales. The Colorado AG's office even developed specific rules for these signals and officially recognized GPC as one approved mechanism.
So if you're in Colorado and use GPC, companies are legally required to treat that as an opt-out.
Correct. For sale and targeted ads, it's a big step for making opt-outs easier for consumers.
Definitely. And that 60-day cure period, just to be clear, ends
January 1st, 2025. After that, it's gone as a requirement. Though Colorado does offer businesses the option to ask the AG's office for informal opinions or guidance, which can help clarify things.
Okay, a sort of alternative path.
Yeah.
What's been the vibe in Colorado since the CPA took effect? Much action.
The AG's office was really engaged during the rulemaking, lots of stakeholder meetings, especially around the opt-out signals. The final rules came out in March 2023.
And enforcement.
They started with an educative approach. In July 2023, they sent out a bunch of notice of assessment letters, basically warnings and guidance. But the expectation is full enforcement starting in 2025, especially with the cure period ending.
Any big legal fights like in California?
Not really, no major court challenges so far. It helped that the CPA passed with bipartisan support. They did amend the law in 2023 to formally kill the cure period after Jan 1, 2025, and to authorize those AG opinions we mentioned.
Okay, so Colorado's definitely one to watch as full enforcement ramps up. Let's hop over to Connecticut. Their CTDPA also took effect recently, right?
Yeah, July 1st, 2023, for most parts. But like Colorado, they delayed the global opt-out signal requirement. That kicks in January 1st, 2025.
Okay, following that pattern, who does the Connecticut law cover?
It applies to businesses doing business in Connecticut or targeting residents and hitting certain thresholds in the prior year, either processing data of 100,000 plus Connecticut consumers or processing data of 25,000 plus consumers if they get over 25% of their gross revenue from selling data.
And consumers means excluding employees again.
Correct. Residents in an individual or household context. Excludes employment and B2B data. Exemptions are similar to government, nonprofits, higher ed, federally regulated data.
Got it. And the rights for Connecticut residents. Similar to Virginia, you said?
Very similar. Access confirmation, correction, deletion, data portability, and the right to opt out of targeted advertising sale and that significant effect profiling.
How quickly do companies need to respond in Connecticut?
They get 45 days with one possible 45-day extension. And they also need that appeal process, including telling consumers how to contact the Connecticut AG if an appeal is denied.
Okay. And enforcement. Who handles it?
Solely the Connecticut Attorney General. No private right of action.
Cure period.
Penalties. They have a mandatory 60-day cure period, but only until December 31st, 2024. After that, just like Colorado, it becomes discretionary for the AG. Penalties can go up to $7,500 per violation, same as Virginia, under their Unfair Trade Practices Act. The AG's office has a privacy committee and has published some guidance and FAQs.
So that cure period deadline is coming up fast in Connecticut, too. End of 2024. What about the universal opt-out signals there? They are requiring them from Jan 1, 2025.
Yes, Connecticut was actually one of the early ones to explicitly require honoring these OPS opt-out preference signals. Starting January 1st, 2025, covered businesses must treat signals like GPC as a valid do not sell, do not share request.
Even if someone previously consented or is in a loyalty program?
Yes. They have to honor the signal. They can ask the consumer later to confirm their preferences, maybe try to get them to opt back in, but they must respect the signal initially. Connecticut is really pushing for these easy opt-outs.
That's a clear message. How about sensitive data like health info in Connecticut?
Again, HIPAA-covered data is exempt, but health data outside HSP is sensitive and you need consent to process it. Connecticut also has a unique rule prohibiting the sale of health and genetic data without explicit consent in some situations. And they have specific language around online monitoring, showing a focus on tracking activities.
Interesting. And that cure period expiring.
End of 2024. After that, the AG can act immediately.
Anything else notable about Connecticut's law?
It was the fifth state with a broad privacy law passed back in May 2022. It really does track Virginia closely, but with those key additions like the mandatory global opt-out recognition and also some specific protections for teens aged 13-15. The AG has been active with education, reminding businesses about that January 2025 opt-out deadline.
Okay, seems like Connecticut is really emphasizing that user control aspect. Let's head down to Delaware next. Their DPDPA is coming online soon too, right?
That's right. The Delaware Personal Data Privacy Act takes effect January 1st, 2025. Delaware became the 10th state with a comprehensive law when it passed in September 2023.
10th state. Wow. Who does the Delaware law apply to? Are the thresholds different?
They are a bit different, potentially more inclusive. It applies to those doing business in Delaware or targeting residents who meet either of two thresholds: controlling processing data of 35,000 or more Delaware consumers, or controlling processing data of 10,000 or more consumers and getting over 20% of revenue from data sales.
Lower numbers there, 35,000 or 10,000 with the revenue condition.
Exactly. So it might capture some smaller businesses compared to other states. Exemptions are similar to Connecticut, Virginia nonprofits. Higher ed, IPA, GLBA data are out. It models CTVA but has its own flavor.
And the rights for Delawareans.
Yeah.
Same core set.
Pretty much. Access correction, deletion, data portability, and opt-out of sale, targeted advertising, and significant effect profiling. The standard 5. You can exercise them twice a year for free, 45-day response time with a possible extension, and the required appeal process.
Okay, familiar ground there. Enforcement in Delaware.
It's the Delaware Department of Justice, the AG's office. No private right of action.
Cure period. Penalties.
Delaware is starting with a mandatory 60-day cure period, but only for the first year through all of 2025. Starting January 2026, that mandatory period expires and it becomes discretionary for the AG.
So another temporary mandatory cure. What about penalties?
They can be up to $10,000 per violation under Delaware's Consumer Fraud Act. That's a bit higher than the $7,500 we've seen elsewhere. A violation of the DPDPA is considered a deceptive trade practice.
Okay, higher stakes potentially. And universal opt-out signals in Delaware.
Yes, they're required from day 1, January 1, 2025. Businesses must honor signals like GPC for opt-outs of sale and targeted ads. Delaware aligned its timeline with Connecticut on this.
So January 1st, 2025. Is a big date for implementing those signals in multiple states.
It definitely is. Companies need to be ready.
How does Delaware handle sensitive data, like health info?
Mostly exempt if it's covered by HIPAA or other Delaware health privacy laws. But DPDPA does include precise geolocation and genetic or biometric data used for identification as sensitive, requiring opt-in consent. Delaware also passed a separate law specifically on genetic data privacy in 2023.
And the mandatory cure period, again, lasts through
all of 2025. Sunsets the start of 2026.
Anything else unique about Delaware's approach?
Well, being enacted later, it seems to have learned from other states. It's seen as fairly business-friendly because there's no private right of action, and it preempts local laws. The DOJ was quick to put out consumer resources. They also have a provision regarding under 18 consent that might be influential elsewhere. It really aligns closely with Connecticut and Colorado on the key points like opt-out signals.
Okay, let's pivot down south to Florida and their digital Bill of Rights. We mentioned there's some debate about how comprehensive it is. When did it take effect?
Key parts took effect July 1st, 2024. And yeah, the debate stems mainly from its narrower scope of who it applies to.
So who does it apply to? And what rights do Floridians get?
It primarily targets larger companies, big tech basically, with high global revenue and specific types of online operations. For those covered companies, consumers get rights to confirm collection, access, delete, and correct their data, and importantly, to opt out of the sale of their personal data.
So the core rights are there, but for fewer companies. Any unique Florida-specific rights?
Yes, a couple of interesting ones. Users under 18 can opt out of personalized content algorithms. Parents can ask for those algorithms to be disabled for their kids. And search engines have to disclose if they're prioritizing results based on political ideology.
That search engine part is definitely unique. What about universal opt-out signals like GPC in Florida?
The Florida law doesn't explicitly require recognizing them. Because its scope is narrower, it focuses more on the covered businesses providing their own clear opt-out methods on their platforms. Those big companies might honor GPC anyway for other states like California, but Florida's law doesn't add a specific mandate for it.
Florida's also been active on kids' online safety, right?
Very. SB 262, the bill containing the Digital Bill of Rights, has a whole section on minor online privacy. It restricts covered platforms from processing minors' data for targeted ads, content recommendations, or profiling without consent. It also requires parental consent for social media accounts for minors.
Separate from the social media age verification law that's faced challenges.
Right, this is part of the Digital Bill of Rights package. That other law is a separate, broader effort.
And how does Florida's Digital Bill of Rights treat health data?
It doesn't single out health data much beyond general personal data, but Florida did pass a separate law in 2023 focused on consumer health data, specifically prohibiting non-consensual location tracking near healthcare facilities. Plus, they have their older Florida Information Protection Act, FIPA, covering data security and breach notification, which does include health info.
Okay, so Florida's approach is a bit more targeted. Let's head back north to Indiana. Their ICDPA has a later effective date, doesn't it?
It does, January 1st, 2026. Indiana passed it in May 2023, giving businesses quite a bit of lead time.
A long runway. Who does the Indiana law cover?
It mirrors Virginia's thresholds. Applies to businesses operating in Indiana or targeting residents who process data of 100,000 plus Indiana consumers annually or process data of 25,000 plus consumers and get over 50% of revenue from selling data. Standard exemptions apply too.
And the rights in Indiana, following the Virginia-Colorado model.
Yes, pretty much. Access, correction, deletion, data portability, and opt-out of targeted advertising, sale, and significant effect profiling. The standard package.
Enforcement and cure period in Indiana.
Enforcement is solely by the Indiana Attorney General, no private right of action. Indiana does have a cure period, 30 days after notice. And interestingly, the law doesn't give this cure period an end date.
So a permanent 30-day cure period in Indiana?
It appears so, based on the current text. That's definitely different from the sunsetting trend we've seen elsewhere. Penalties are up to $7,500 per violation if not cured.
Okay, Indiana stands out with that permanent cure. What about global opt-out signals?
Indiana's law doesn't explicitly mention them. It follows the older model focusing on opt-outs via user request methods provided by the business itself. So, no mandate for GPC recognition as it stands.
And sensitive data, like health info in Indiana?
Standard approach here. High-pay regulated data is exempt. Non-HIPAA health data falls under sensitive data, and businesses need opt-in consent to process it. Includes things like biometric, genetic data, too.
And that cure period is definitely permanent, 30 days.
As far as the current law states, yes.
Any other unique points about Indiana's law?
Well, besides the permanent cure period, the long lead time is notable. It also establishes a consumer privacy fund, where collected penalties go, intended to support future privacy efforts. But largely, it tracked the Virginia model fairly closely.
Okay, let's keep moving. How about Iowa? Their ICDPA also starts in early 2025, right?
Yes, Iowa's law takes effect January 1st, 2025. It was signed back in March 2023.
And the scope in Iowa? Similar thresholds?
It mimics Utah and Virginia. Applies to businesses operating in Iowa or targeting residents who process data of 100,000 plus Iowa consumers or process data of 25,000 plus consumers and get 50% or more revenue from data sales. Standard exemptions too.
Now, Iowa's law is often called one of the most business-friendly.
Yeah.
How does that show up in the rights?
It definitely grants a more limited set of rights. Consumers get access, deletion, portability, and an opt-out, but only if sale.
Just sale. And how is sale defined?
Narrowly. It's defined as exchanging personal data for monetary consideration only, so other value exchanges might not count.
What's missing compared to other states?
No right to correct data inaccuracies, no right to opt out of targeted advertising or profiling, and no mandated appeal process if a request is denied.
Wow, okay. That is significantly different. Enforcement and cure period in Iowa.
Enforcement is solely by the Iowa Attorney General, no private lawsuits. Iowa provides a longer cure period 90 days after notice. And like Indiana, this 90-day cure period has no sunset date. It appears to be permanent.
90 days and permanent. Definitely business-friendly. Penalties.
Up to $7,500 per violation if not cured within those 90 days.
In universal opt-out signals in Iowa.
The law doesn't address them at all, just requires some mechanism for opting out of sales, as narrowly defined, but no mandate for GPC or similar signals.
What about sensitive data or kids' data in Iowa?
Iowa's law is pretty quiet there, too. There's no requirement for opt-in consent for sensitive data. The term isn't even really defined. And no specific rules for kids' data beyond just complying with the federal COPE data law.
Okay, and that permanent 90-day cure period confirmed.
Yes, 90 days, no sunset.
It's very clear why Iowa gets that business-friendly label. Quite different from California or Colorado.
Absolutely. It represents a different model, more akin to Utah's approach, perhaps.
All right, let's head west to Montana, their MCDPA. When does that kick in?
Montana's law takes effect October 1st, 2024. And they also have a universal opt-out signal requirement coming soon after by January 4th, 2025.
Joining the opt-out signal trend, who does Montana's law apply to?
Businesses operating in Montana or targeting residents who process data of 50,000 plus consumers annually, or process data for 25,000 plus consumers if over 25% of their revenue comes from data sales. Standard exemptions apply.
And the rights in Montana, full suite.
Yes, pretty comprehensive. Access confirmation, correction, deletion, getting a copy, portability, and opt-out of targeted advertising, sale, and that significant effect, solely automated profiling, plus the required appeal process.
Okay. Enforcement penalties cure period in Montana.
Enforcement is by the Montana Attorney General, no private right of action. The law itself doesn't state a penalty amount, but the AG can use unfair trade practice laws, so likely the $7,500 benchmark again. They do have a 60-day cure period, but it's temporary.
Temporary? When does it expire?
It expires on April 1st, 2026. After that, it lapses, and the AG isn't required to offer it.
Okay, another sunsetting cure period, and the universal opt-out signals are required by?
January 1st, 2025. They need to honor a user-selectable universal opt-out mechanism for targeted ads and sales, so GPC or similar.
How is health data treated in Montana?
It's considered sensitive data, requiring consumer consent before processing. Montana's definition explicitly includes mental or behavioral health condition, which is notable.
And that 60-day cure is definitely gone after April 1st, 2026.
Correct. Expires then.
Any other updates from Montana?
Yes. They amended the law in 2023 to add requirements effective January 1st, 2025. Businesses now need to do data protection assessments, DPIAs, for high-risk processing like targeted ads, selling data, or processing sensitive data. They also added requirements for data processing agreements between controllers and processors.
So adding some GDPR-like elements there with the DPIAs. Okay, let's talk Nebraska. Their NDPA is another one starting in 2025, right?
Yes, Nebraska's Consumer Data Privacy Act took effect January 1st, 2025. It passed in April 2024, so it's quite recent.
And the scope in Nebraska?
It applies to those doing business in Nebraska or targeting Nebraskans who control process data of 50,000 plus consumers, or if they derive over 50% of revenue from data sales and process data of 25,000 plus consumers. It's similar structure to Colorado, but that first threshold is 50K, not 100K. Standard exemptions apply.
Rights in Nebraska.
Looking like access, correction, deletion, portability, and opt-out of sale and targeted advertising. It seems like the explicit profiling opt-out might not be in the final version, but that needs confirmation. An appeal process is expected.
Enforcement, cure, penalties in Nebraska.
Nebraska AG enforces no private right of action. There's a 60-day opportunity to cure, but again, it's temporary. It expires January 1st, 2026. Penalties up to $7,500 per violation after that cure period, or if not cured.
So mandatory cure through 2025, then discretionary, universal opt-out signals.
Yes, Nebraska's law does mandate recognizing universal opt-out mechanisms effective in 2025. Less publicized than some states, but it aligns with the trend.
Sensitive data requires opt-in.
That's the expectation, yes. Opt-in consent for sensitive categories.
And the cure period expires end of 2025.
Correct. Mandatory until Jan 1, 2026.
Any other notes on Nebraska?
Being enacted in 2024, it seems to borrow heavily from laws like Connecticut's. Shows that states are increasingly looking at existing models as they draft their own legislation.
Makes sense. How about New Hampshire? NHDPA, also starting January 1, 2025.
That's right. New Hampshire Data Privacy and Protection Act, effective Jan 1, 2025.
Scope in New Hampshire. Thresholds.
Applies to entities doing business in NH or targeting residents who control process data of 25,000 plus NH consumers, or control process data of 10,000 plus consumers and get over 50% revenue from data sales. These are relatively low thresholds, standard exemptions.
Rights in New Hampshire.
Full suite again. Access, correction, deletion, portability, and opt-out of sale, targeted ads, and significant decision profiling. Similar to Virginia, Colorado. It also emphasizes data minimization and requires consent to collect sensitive data or data beyond what's necessary for the purpose.
Enforcement, cure, penalties.
New Hampshire AG enforces no private lawsuits. Penalties up to $10,000 per violation, a bit higher again. There is a 60-day cure period, but it expires December 31st, 2024. No statutory right to cure after that, just AG discretion.
So the mandatory cure in NNH ends really soon, end of 2024. Opt-out signals.
The law requires a mechanism for opt-out. While not as explicit as Connecticut, the practical expectation is that businesses will need to honor OOPS like GPC, especially since they'll likely need to for Connecticut starting Jan 1, 2025 anyway.
It's practical sense. And no mandatory cure after 2024.
Correct. Discretionary only from 2025.
Okay, let's jump to New Jersey. NJDPA. Also early 2025.
Yes, January 15, 2025 for the New Jersey Data Privacy Act.
Scope in New Jersey.
Entities doing business in NJ are targeting residents who control process data of 100,000 plus consumers, or control process data of 25,000 plus consumers and derive any revenue or discount from data sales. This threshold seems broad. Standard exemptions.
Rights in New Jersey.
Access, correction, deletion, portability, and opt-out of sale and targeted advertising. Again, maybe no explicit profiling opt-out. Requires an appeal process. Also requires disclosing loyalty program impacts if someone opts out.
Enforcement, cure, penalties.
New Jersey AG enforces no private right. There's a temporary cure period. The AG may grant 30 days during the first 18 months until mid-2026. After that, it's fully discretionary. Penalties up to $10,000 for the first violation, up to $20,000 for subsequent ones under the Consumer Fraud Act, potentially higher than some others.
Higher penalties again.
Yeah.
Opt-out signals.
Yes, New Jersey's law requires honoring universal opt-out signals for sales and targeted ads, effective Jan 15, 2025.
And that cure period is discretionary after mid-2026.
Correct. Limited mandatory window initially.
Okay, moving fast. Oregon next. OCPA. Effective mid-2024, but delayed opt-out signals.
Exactly. Oregon Consumer Privacy Act effective July 1st, 2024. But the obligation to honor universal opt-out signals is delayed until January 1st, 2026.
Giving businesses more time there. Scope in Oregon.
Persons doing business in Oregon or providing services products to residents who process data of 100,000 plus consumers or process data of 25,000 plus consumers while deriving over 25% revenue from sales. Standard exemptions.
Rights in Oregon.
Full set. Access, correction, deletion, portability, and opt-out of targeted ads, sale, and significant effect profiling.
Enforcement, cure, penalties.
Oregon AG enforces no private right under OCPA itself. There is a limited 30-day opportunity to cure, but only for violations notified before January 1st, 2025. No ongoing cure mandate after that date. Penalties up to $7,500 under their Unlawful Trade Practices Act.
So that limited cure window is already closed. And the opt-out signal deadline is Jan 1, 2026. The AG is approving mechanisms.
Yes, the Oregon DOJ is tasked with approving mechanisms by early 2025, giving businesses that year lead time before the 2026 deadline.
Now, Oregon also has that separate, stricter health data law.
Right. Yes, very important. Under OCPA itself, health data is sensitive and requires consent. But Oregon also has the Oregon Consumer Health Data Act, effective July 2024. It's much stricter, applies to non-HIPAA health data very broadly, and crucially, it has a private right of action.
Private right of action for the health law. Wow.
Yeah, that's a major difference. Businesses handling health data in Oregon need to pay close attention to both laws.
And the limited cure under OCPA is already passed.
Correct. No ongoing cure period there.
Okay, Tennessee next. TIPA. Effective mid-2025 with a unique revenue threshold.
Yes, Tennessee Information Protection Act, effective July 1st, 2025. It applies only to businesses exceeding $25 million in revenue and meeting data processing thresholds. Either 175,000 plus consumers or 25,000 plus consumers with over 50% revenue from sales. Standard exemptions.
That revenue floor is key. Rights in Tennessee.
Full suite. Access, correction, deletion, portability, and opt-out of targeted ads, sale, and significant decision profiling, though they allow declining dilution correction if the data isn't reasonably linkable.
Enforcement, cure, penalties.
Tennessee AG enforces explicitly no private right of action. There's a 60-day right to cure, but it's temporary mandatory through December 31, 2025, then discretionary for the AG from 2026. Penalties up to $7,500 per violation.
Well, higher penalties sometimes.
Yes, penalties can be doubled up to $15,000 for violations involving known under 13 data or certain sensitive data categories.
Oof, universal opt-out signals in Tennessee.
No mandate. TIPA doesn't require recognizing them.
Sensitive data requires opt-in.
Yes, health data is sensitive, requires consent.
And the cure period is mandatory through end of 2025, then discretionary.
Correct.
Texas, TDPSA. Effective mid-2024 with a small business exemption.
Yes. Texas Data Privacy and Security Act, effective July 1st, 2024. Applies to businesses conducting business in Texas unless they qualify as a small business under SBA standards. Thresholds are processing selling data of 50,000 plus Texans or selling data of 25,000 plus Texans. Standard exemptions.
Rights in Texas.
Access, correction, deletion, portability, and opt-out of sale and targeted advertising. No explicit profiling opt-out.
Enforcement, cure, penalties.
Texas AG enforces no private right. There was a 30-day discretionary cure period, but it gets repealed entirely on September 1st, 2025. So very limited window, penalties up to $7,500 to violation plus $250 per consumer for unlawful sensitive data sales. And Texas is creating a future data privacy protection agency.
They started enforcing right away too, didn't they?
Yes. The AG filed the first action on day one. Sends a strong message.
What's the deal with opt-out signals in Texas? It sounded unique.
It is. TDPSA itself doesn't mandate honoring them, that says businesses may use third-party tools and the AG can approve them. Use isn't required by TDPSA. However, a separate 2023 amendment does require GPC recognition for opt-outs of sale by certain data brokers starting Jan 1, 2025. So it's complicated.
It's very specific. Sensitive data needs opt-in.
Yes. Includes health diagnosis, biometrics, genetic data, requires opt-in consent. Texas also has existing medical records and biometric privacy laws.
And that discretionary cure is gone after September 1st, 2025.
Correct. Then no cure period.
Okay, almost there. Utah, UCPA, effective end of 2023 with a revenue threshold.
Yes. Utah Consumer Privacy Act, effective December 31st, 2023. Applies to controllers processors in Utah with $25 million plus annual revenue and meeting data thresholds. 100,000 plus consumers or 25,000 plus with 50% revenue from sales. Standard exemptions.
Utah is also seen as business-friendly. How are the rights?
Narrower. Access, deletion, but only data the consumer provided, portability, and opt-out of targeted ads and sale, narrowly defined as monetary exchange. No right to correct, no profiling opt-out, appeal process exists, but no requirement to tell consumers how to contact the AG.
Enforcement, cure, penalties.
Utah AG enforces no private right, has a permanent 30-day cure period after notice. Penalties up to $7,500 per violation if not cured.
Permanent 30-day cure like Indiana. Opt-out signals.
No mandate in UCPA to recognize browser or global signals.
Sensitive data approach in Utah.
This is unique. Utah allows an opt-out for sensitive data processing rather than requiring opt-in consent like most other states.
Opt-out for sensitive data. That is different. And permanent 30-day cure confirmed.
Yes, permanent 30-day cure.
Okay. Last comprehensive one, Virginia, VCDPA, effective early 2023.
Yes, Virginia Consumer Data Protection Act, effective January 1st, 2023. One of the first. Persons doing business in Virginia or targeting residents who control process data of 100,000 plus consumers or 25,000 plus consumers and derive over 50% revenue from data sales. Yeah. Standard exemptions.
Right, say CNA, the core five.
Yes, access, correction, deletion, portability, and opt-out of targeted ads, sale, and significant effect profiling. Requires the appeal process and telling consumers how to contact the Virginia AG upon denial.
Enforcement, cure, penalties.
Virginia AG enforces no private right. Had a mandatory 30-day cure period, but that expires January 1st, 2025. After that, it becomes discretionary. Penalties up to $7,500 per violation.
Another cure period sunsetting Jan 1st, 2025. Opt-out signals in Virginia.
No requirement to honor global opt-out signals in VCDPA.
Sensitive data requires opt-in.
Yes, health data is sensitive, requires consent. Virginia also has a separate Genetic Data Privacy Act.
And mandatory cure ends Jan 1st, 2025.
Correct. Becomes discretionary then.
Okay, one more crucial one, though not comprehensive. Washington's My Health, My Data Act. MHMDA. When did that take effect?
Mostly March 31st, 2024 for large orgs, June 30th, 2024 for small ones. Focus specifically on health data, but very broadly.
How broad is the scope?
Extremely broad. Applies to any regulated entity collecting consumer health data from WA residents. Regulated entity is almost anyone. Consumer health data definition is vast. Anything linkable that identifies past, present, future physical or mental health. Diagnoses, treatments, biometrics, even just seeking healthcare. High PLA entities are exempt, but otherwise it's huge.
Wow. Rights under MHMDA.
Access, deletion with instructions to partners, withdrawal of consent, and portability, getting a list of third parties shared with, plus data copy. No correction rights specifically. Also prohibits geofencing around healthcare facilities, requires a specific consumer health data privacy policy, prohibits coercive consent.
Enforcement. Cure period. This sounds like it has teeth.
Big teeth. Enforced by the Washington AG and a private right of action under the State Consumer Protection Act, except for small orgs. Individuals can sue directly. Potential for treble damages for willful violations, and crucially, no formal cure period.
Private right of action and no cure period for health data. That's massive.
It really is a game changer for health data outside IPA.
Opt-out signals under MHMDA.
Not really relevant because it's so opt-in focused for health data. You need consent to collect share, so the issue is withdrawing consent, not a general opt-out signal.
Kids data?
No separate rules, but applies equally. Its broad definitions and consent rules might be stricter than CAPUPA for teens' health data in practice.
And no cure period confirmed.
Correct. No formal cure period.
Phew. Okay, that was an incredible whirlwind tour of, 18 different state approaches? It's a lot. But looking across all of them, what are the big picture trends you're seeing emerge?
Yeah, it's definitely a complex map. But some clear themes are emerging. First, just a huge expansion of consumer rights pretty much everywhere. Access, delete, correct, opt-out are becoming standard baseline expectations.
Right. Those core rights keep popping up.
Then, while the scope thresholds vary a bit and definitions like sale can differ, there's some convergence. But those subtle differences still matter a lot for compliance.
Definitely. What else?
A massive emphasis on sensitive data. Opt-in consent for things like health info, biometrics, precise location, that's becoming the norm. Utah being a notable exception with its opt-out.
And kids' data, too.
Huge focus there. Age gating, stricter consent rules, especially for teens in some states, and the rise of global opt-out signals, GPC primarily, is undeniable. So many states are mandating recognition now.
That seems like a big win for usability.
It is another major trend. That right to cure is definitely fading. So many states are sunsetting mandatory cure periods, moving towards immediate enforcement discretion for the AGs.
Less room for error for businesses.
Exactly. We're also seeing new regulators pop up, like the CPPA in California, maybe one coming in Texas. And while it's still a patchwork, there's this background pressure, maybe pushing towards some level of harmonization, or at least businesses aiming for the most stringent standard.
And those sector-specific laws keep coming too, right? Like the health data ones.
Yep. Health, biometrics, AI now. That's continuing. Enforcement is starting to ramp up, maybe cautiously, but definitely increasing. We're seeing potential for multi-state actions, and that private litigation risk, especially with laws like Washington's MHMDA, is real.
It all just keeps putting pressure on Congress for some kind of federal law, doesn't it?
You'd think so, but in the meantime, the states are definitely not waiting. The patchwork grows.
So for businesses trying to navigate all this, what are the big takeaways? What do they need to be doing?
It's a lot. They absolutely need solid workflows for handling all these consumer rights requests efficiently and accurately. They have to grapple with those differing definitions and requirements state by state.
Consent management seems huge.
Crucial, especially for sensitive data and kids' data. Age verification processes need careful thought. Implementing and honoring those global opt-out signals is becoming non-negotiable in many places.
And preparing for enforcement without that cure period safety net.
Right. The best bet for many is probably to aim for a high baseline standard that covers the toughest requirements across the states they operate in a sort of internal U.S. privacy framework.
Stay vigilant for new laws, too.
Absolutely. Especially those sector-specific ones. Proactive documentation of compliance is key, maybe even building relationships with regulators where possible. It really means investing seriously in privacy programs, data mapping, consent tools, security, and critically training employees.
It sounds like a major operational lift. And I have to imagine resources like our sponsor, globalcompliancemap.com, become pretty vital in keeping track of all this.
Incredibly valuable. Staying current when the landscape shifts this fast is a huge challenge, and having reliable resources makes a massive difference.
It really feels like it's not just about legal compliance anymore, is it? It's about consumer trust.
That's a huge part of it. Consumers are way more aware now. They expect transparency, they expect control. Building that trust through strong privacy practices isn't just good ethics, it's good business. It can be a real advantage.
And again, for businesses looking for help in this area, our sponsor, globalcompliancemap.com, offers resources specifically designed for this kind of challenge.
Definitely worth checking out if you're navigating these waters.
Well, this has been incredibly illuminating, a real deep dive into a very complex but super important area. What's the final thought you want to leave everyone with?
Just that this state privacy law landscape is incredibly dynamic. It's not static. It requires ongoing attention, whether you're an individual wanting to know your rights or a business needing to comply. The momentum is clearly towards giving consumers more power over their data.
Absolutely. So we really encourage you, our listeners, to think about how these laws impact you directly. Check out your own state's rules or the rules in states where you operate. The Attorney General websites are often a good starting point.
And the trend seems set to continue. More states are likely to act, pushing the bar higher. Staying informed isn't just helpful, it's becoming essential.
We absolutely need to thank our episode sponsor, globalcompliancemap.com, one more time. Their support in making this detailed exploration possible is truly appreciated. Their platform is such a key tool for anyone dealing with compliance globally.
Absolutely. Their commitment to clarity in this complex field is invaluable.
Okay, that wraps up our deep dive for today. But here's something to chew on. As more and more states keep adding their own unique layers to this privacy patchwork, how do you think it ultimately shapes the national conversation? Will this pressure finally lead to a unified federal standard to simplify things? Or will we just keep navigating this complex state-by-state reality? Something to think about. Thanks for joining us.